we talked about revision of the register. My lords and my ladies, the issue that then we'll need to make clear in the main ground of appeal is the mischaracterization of the use of the word revised and continuous registration of voters. So kindly, my lords and my ladies, have that in mind, because it is an important issue that arises from a misreading of those two statutes. Most obliged.
All right. I hope we can now continue. We have spent about 35 minutes on some procedural aspects. I think it is not time wasted, but we must be able to move on. Mr. Ogeto, you are just beginning, and so the time will run from now, your 2 hours. It is 10:07. Proceed.
Thank you very much. My lords, my ladies, let me start, my lords and my ladies, by saying that it will be amiss of me not to say how deeply honored I am this morning to appear before you on behalf of the Honorable the Attorney General. And before I proceed, my lords, my ladies, I know you had given us 2 hours to do our submissions, and that applies to all the appellants. But I just want to point out to my lords and my ladies that the team of His Excellency the President has very graciously donated 30 minutes, 30 extra minutes to us. And that is the result of the fact that we cover much more ground in terms of our grounds of appeal. And so, my lords, I just want to notify the court that instead of the 2 hours, we also have 30 minutes from His Excellency the President for us to be able to be helpful to the court.
Well, that's what we said in our direction. As long as the issues that you're covering are cross-cutting, and those who are coming after you will not be requiring to take an equal amount of time on the same issues. It is okay, as long as you have organized yourselves.
So thank you very much, my lord and my lords and my ladies. My lords, we have filed 31 grounds of appeal, and those grounds will be found at page 1 of our volume 1 of our record of appeal. But we propose, my lords, to argue those grounds in the form of thematic areas. And allow me, my lords, to outline those thematic areas and to place our appeal in proper context. The first...
How many are the thematic areas?
The thematic areas, my lord, are 9 thematic areas. The first thematic area is the applicability of the basic structure doctrine, and that will cover grounds 1 to 5, 17 and 18. The second thematic area will be the constitutional remit of popular initiative and the question of public participation, grounds 7 to 17. The third thematic area, my lords, my ladies, the creation of additional constituencies, ground 24. The question of presidential immunity, the fourth thematic area, that will cover grounds 19 to 23. The fifth thematic area, the quorum of the Independent Electoral and Boundaries Commission, grounds 25 and 26. The sixth thematic area, adequacy of legal infrastructure to support signature verification. Grounds 27 to 29.
Yes.
The seventh thematic area is the single or multiple referendum questions. Ground 31. The issue of voter registration as relates to holding of a referendum will be the next one. And finally, and that will cover ground 30. And
yes.
Finally, the question of the role of amicus curiae, ground 6.
All right, start with the number 1, the applicability of basic structure doctrine.
My lords, the way we want to do that is that my colleagues will handle each of those thematic areas.
Right.
But for me, I want to give you highlights of the essential aspects of our appeal. Then I'll let my colleagues deal with the specific aspects of these thematic areas. In other words, I just want to do an opening statement, my lords. My lords, let me start by stating at the outset that our appeal is nothing more than a plea to this honorable court for fidelity to our Constitution. It is simply a call to this honorable court of the people's sovereign will. Through our appeal, my ladies, my lords, we invite this honorable court to affirm the Constitution as enacted by the people of this great republic. We also invite this honorable court to affirm that it is not for this court or for any other court to rewrite our Constitution. My lords, my ladies, our submissions will seek to demonstrate, among other issues, that, one, the learned judges of the High Court disregarded clear provisions of the Constitution in order to arrive at a decision. The learned judges effectively amended the Constitution. Number 3, the learned judges of the High Court disregarded decisions made by their colleagues in the High Court, in the Court of Appeal, and indeed the Supreme Court. And 4, the learned judges disenfranchised millions of Kenyan voters by ignoring their popular initiative. We will be submitting that the judges did this through personalized attacks against His Excellency the President of the Republic of Kenya that climaxed in factually and legally unfounded conclusions. An example of this, my lords, my ladies, is the unprecedented finding that a president can be sued in a personal capacity for official acts. On the disregard of the Constitution, my lords, my ladies, we will demonstrate that our Constitution has no place for the application of the basic structure doctrine. Chapter 16 of our Constitution, my lords, my ladies.
Just wait. Can you just repeat? The plane was passing by making noise. Just repeat.
Sorry, my lady.
Just repeat what you are saying before you come to what you want to start on now.
My earlier submission, my lord?
No, her lordship is saying that there was loud noise from a passing helicopter She requests that you repeat what you just said, the last statement. I think about the basic structure.
After the personal attacks to the president.
Okay. On the disregard of the Constitution, my lords, my ladies, we will demonstrate.
I think, Mr. Ogeto, the last thing you addressed before the plane took your voice away was something about the Constitution having no place for something, for the basic structure, I think. That's
Yes.
what you need to repeat for
Yes.
us to get it right.
Yes, and what I'm saying in our submissions, my lords, my ladies, is that our Constitution has no place for the application of the basic structure doctrine. Chapter 16 of our Constitution, my lords and my ladies, provides that our Constitution may be amended either through parliamentary initiative or popular initiative. The chapter confirms that all the provisions of our Constitution are amendable. Articles 255 and 257 in chapter 16 direct us in very clear detail how the Constitution may be amended. The provisions, my lords, my ladies, tell us which amendments require a referendum and those that do not require a referendum. The provisions prescribe the majorities required in either House of Parliament to pass an amendment. They also guide us on the majorities required to pass an amendment in a referendum. We submit, my lords, my ladies, that there is no limitation to this amendment power. Our Constitution, in other words, is self-contained. There is no room for drawing inferences on the rules of amending the Constitution or for relying on extraneous factors. There is no mention in our Constitution of an amendable or eternal clauses in our Constitution. The learned judges themselves admitted as much in paragraph 473 of their judgment when they noted, and I quote, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable." End of quote. Yet, my lords, my ladies, the learned judges proceeded to conclude that the basic structure doctrine was applicable in Kenya. To be clear, my lords and my ladies, many of the democracies desiring to make their constitutions unamendable have done so explicitly. And we have examples which we have articulated in our submissions. Germany, Italy, France, Senegal, Gabon, and Morocco. We shall submit, my lords, my ladies, that courts have adopted the basic structure doctrine where amendments are exclusively by Parliament. We do not have a single decision globally where courts have declared that the basic structure doctrine applies in a situation of a referendum.
Perhaps, Mr. Ogeto, when you get to the meat of that, you might want to address the issue of Colombia when you get to the meat later on.
We will do that, and in Colombia what they've done, my lords, because we have looked at that constitution, is that where the intention of the makers of the constitution intended that you have a constituent assembly, they provided for it expressly in their constitution. We shall demonstrate that the people of Kenya consciously and deliberately avoided the basic structure doctrine. They chose a different method of safeguarding the fundamental provisions of their constitution. This method is what is laid down in Chapter 16. Once this method has been followed, the people of Kenya can amend any provision in their constitution. Chapter 16, my lords, my ladies, was our balance between hyper-amendment, which was the concern of the High Court, on the one hand, and rigidity on the other hand. And we invite my lords and my ladies to look at the final report of the Constitution of Kenya Review Commission, 2005. This report, my lords, emphasized the need for this important balance at page 74 of that report. And we have reproduced that report.
Yeah, where is it contained in the record of appeal, please?
Contained at page 12 of the amended case digest and pages 49 to 51 of the appellant's abridged bundle of authorities. And if you allow me, my lords, my ladies, just to quote briefly from this report, the quote, what they said: there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, and that is important, my lords, a balance must be struck between these two extremes. At page 75 of the report, the Commission proceeds as follows, and I quote: many Kenyans expressed fears that even after a comprehensive review of the Constitution, Parliament, and the emphasis on Parliament, Parliament may thereafter sit and make substantial amendments that would water down all their efforts. In addition, it was generally felt that the current provision for amending the Constitution was too simple and therefore been used to consolidate power in the executive. The people, therefore, wanted fairly rigid arrangement, the amendment of which would require their participation in some form. This is what the CKRC report says. On this basis, my lords, my ladies, at page 76 of that report, there was a recommendation for a distinction in the amendment procedures for entrenched provisions and non-entrenched provisions. And my lords, my ladies, this distinction in the CKRC report is exactly what is reflected in Chapter 16 of our Constitution. This chapter captures the people's concerns and aspirations with regard to the power to amend the Constitution. We submit that it balances between rigidity and amendability. There was never an intention to make certain parts of our Constitution unamendable, because if that was the case, then the makers of our Constitution would have expressly stated so in the Constitution. My lords and my ladies, we shall demonstrate that in practice, Chapter 16 has been very successful in safeguarding the Constitution against the culture of hyper-amendment. You will notice, and we have demonstrated that in our submissions, that since the promulgation of the Constitution, there have been approximately 22 failed attempts to amend it. 2 through popular initiative and 20 through parliamentary initiative. And we have detailed those in Schedule 2 to our submissions dated 8th of June 2021. On the second issue, my lords, my ladies, we shall show that the learned judges effectively purported to amend the under the guise of interpretation. In paragraph 474G of the judgment, the learned that they purportedly to case basis. Lords, my ladies, we need to note this very carefully. And if this understanding is to hold, the courts would have the role of vetting proposed amendments before the same are dealt with in accordance with Chapter 16. And yet, my lords and my ladies, there is no such role for the courts in our Constitution. In paragraph 615 of the judgment, the learned judges held that each of the proposed amendment clauses ought to be presented as a separate referendum question. We submit, and in our submissions, that this holding clearly contradicts Articles 257(10) of the Constitution, which identifies in very clear terms that an amendment bill as the subject matter of a referendum. In paragraph 546 of the judgment, the learned judges impose immunity. This, again, we submit, my lords, my ladies, contradicts Article 143 of the Constitution, which gives a serving president absolute immunity from civil proceedings while exercising his official functions. On the third matter, my ladies and my lords, we shall show that the learned judges ignored court decisions from their own High Court, the Court of Appeal, and even the Supreme Court. In this regard, we shall point out the following. One, the learned judges' decisions to the provides adequate means for amending the Constitution. And two, just as illustration, the learned judges ignored a finding by the High Court that the IEBC, as currently constituted, are quorum. In paragraph 491 of the judgment, the learned judges claimed that the popular initiative mechanism is exclusively available to the private citizen, as opposed to a state organ or His Excellency the President, or more generally the government. My ladies and my lords, we shall show that the learned judges established a non-existent dichotomy in the use of the popular initiative. And by this, the learned judges disenfranchised nearly 4 million registered voters under the pretext of nullifying alleged unconstitutional acts by His Excellency the President. Our very humble view, and with utmost respect, my lords and my ladies, is that the essence of a popular initiative is that it has to be popular by satisfying the majorities stipulated in the Constitution and nothing more. The initiative only becomes an initiative upon obtaining the endorsement of at least 1 million registered voters. The Constitution is very clear. It does not provide for the origin of a proposal to amend the Constitution through popular initiative. There is also no basis, my lords, my ladies, for the claim that the popular initiatives are by definition anti-government, because this was the finding of the Superior Court. And you will notice, my lords, my ladies, that this regrettable claim resulted partly from the learned judges' reliance on Wikipedia. They resorted to Wikipedia as an authority. And for sure, Wikipedia cannot be a reliable authority for anything serious, my lords, my ladies. If you look at Wikipedia, if you do a Google search of Wikipedia, it describes itself, and I quote, the free encyclopedia that anyone can edit, end of quote. So therefore, my lords, my ladies, a source that is so open to manipulation cannot be a reliable source of legal authority. In paragraph 490 of the judgment, the learned judges held that the Constitution of Kenya Amendment Bill 2020 is an initiative of His Excellency the President. My lords and my ladies, this was a fundamental factual error on the part of the judges. To be clear, we will be submitting that nothing in the Constitution prevents His Excellency the President from originating an amendment proposal to the Constitution. Even so, in the present case, my lords and my ladies, His Excellency the President never played the role that the learned judges claimed that he did. The learned judges simply ignored the evidence that was adduced as to who the promoters of the amendment bill were. And with utmost respect, my lords and my ladies, it seems to us that the learned judges were keen on very personalized attacks against the person of His Excellency the President. To them, the facts and the law did not matter. Neither did precedent nor the sovereign will of the people of the Republic of Kenya. The person of His Excellency the President just had to be found at fault, regardless of the consequences of such a finding on the people of Kenya and their sovereign power. In sum, my ladies and my lords, we will demonstrate that the learned judge's verdict was only possible because they either ignored or amended the Constitution and the law. At the end, the judges elevated their personal opinions and preferences over the Constitution and over the will of the people of this great republic. And therefore, my lords and my ladies, our plea to this honorable court is that it reverses the extra-constitutional and anti-constitutional step taken by the High Court. We urge the court to affirm the letter and the spirit of our Constitution. My lords and my ladies, we humbly invite you to end this clear onslaught, and we call it onslaught, in a very considered manner, on the sovereignty of the people of Kenya. We submit that the people must retain their sacrosanct right to live by the Constitution that they chose for themselves and to develop it as they may wish. That is the only way to preserve a rule-based civilization. And I wish to quote the famous Irish philosopher Edmund Burke, who has warned us, and I quote, "A state without the means of some change is without the means of its conservation," end of quote. My lords and my ladies, as I conclude, and with your kind permission, I should like to indicate that my learned colleagues will address the council who is leading us will address the question of the applicability of the basic structure doctrine public participation and the approach to referendum questions. Mr. Kamau Karori will address the question of the remit of popular initiative and the creation of additional constituencies and the quorum of the IEBC. He will also deal with the question of amicus curiae. With your permission, I will return to address you on the question of presidential immunity. My learned friend, Mr. Nyamodi, with your permission, will be replying to the respondent. Thank you very much.
Okay. Just sort of. Let him ask him whether we take a break now to continue. All right. Thank you very much, Mr. Ogeto, for that introduction of the issues that are going to be dealt with and the order in which council you're appearing with will address the issues. What we intend to do is to take a short break now. We craft a short ruling, and when we come, we now begin with the senior counsel, Mr. Oraro, and then we continue with the others who are addressing the thematic areas.
Thank you, my lord.
Yes.
I'm obliged.
All right. So we'll be back after about 30 minutes.
That's the tip. I assume this is the tip. This is the tip. This is the tip break. Yeah, because I can't hear it being, and then we go for tip break. I think we started well.
Many more objections, but
No, we started well. And you see the beauty about some of our arguments. There are no arguments you can play about. Yeah, I think I'll run to Trattoria and I get up a cup of tea.
the only big advantage I have over you all is I'm still here.
Ati?
No? The biggest advantage I have over you all is that I'm still here. My office is still here.
Your office is just near here. Yeah.
Good. It appears that today is the biggest day.
Yeah, I think today is very good. I think you can just now you are going to have to take. I don't know whether you need to take a break. Yeah. In fact, we can even